California Probate Code and the Notice of Proposed Action is our topic today. Let's get started. Welcome back to my channel. If you're new here, I'm Kim Ward. I'm a real estate broker in San Diego County and an expert at helping executors, administrators, and trustees with homes in probate or trust administration. Today's topic is the California Probate Code and the Notice of Proposed Action. Selling a property in probate requires either court approval or a Notice of Proposed Action. The Notice of Proposed Action is part of a procedure authorized by the Independent Administration of Estates Act. It allows the sale of a property in probate without court approval in most cases. If all of the beneficiaries consent or fail to object, then you as an executor or an administrator would not have to obtain full court approval for the sale of your loved one's home. So when is a Notice of Proposed Action, or a NOPA, when is it authorized? To make the administration of a California probate easier, California adopted the Independent Administration of Estates Act, or IAEA. What it does is it permits the personal representative, the executor or the administrator, to administer certain tasks involved in a probate without court approval. This allows you to go forward without court approval, supervision, or instruction from the courts. To receive the authority under the IAEA, you or your attorney must request the authorization in a probate petition. In California, it's merely a box that needs to be checked when submitting the documentation to the courts. The courts can give you full authority or limited authority. It's best to get full authority because then you can act under that IAEA. If you're given limited authority, you will then most likely need to have court approval, which is a longer period of time because documentation needs to be submitted to the courts and then a court date needs to be established. And usually that's within about a 30-day period, but lately it's been longer because of having the backup of probates because of the coronavirus situation. But today we're going to talk about as if you've been granted full authority under the IAEA. And you can go ahead and go forward with the sale of the property without court approval. But first, a Notice of Proposed Action must be served on all the beneficiaries. So we know that the IAEA gives you broad authority to manage many of the tasks within the probate. For example, one of the broad powers that you would have is being granted the full powers to manage the piece of real estate with a few caveats. One of the things that you need to be aware of is that here in California, there will be a probate referee appraisal. And basically, it's an appraisal that's done by the probate referee on your loved one's property. And what's important to you is that you need to have sold the property or be in the process of selling the property for no less than 90% of the probate referee appraisal. Now, I've been doing this over 17 years and I've never had an issue except for one that was just kind of a weird situation that we corrected. So you don't need to worry about it, that we've never sold a property for less than that 90% that the courts want to see. If for whatever reason you were selling the property for less than the 90%, then you would need to require court approval in order to go forward with the sale. But like I said, don't worry about it. It's highly unlikely to happen. So what protects you is that under those IAEA and the Notice of Proposed Action, you need to serve that on everyone that is interested in, legitimately interested in the estate. You'll want to serve that notice on them before you take any action, and we'll get a little bit deeper into that in a bit. So of course, you just can't do whatever you want, even though you have been appointed as the executor or the administrator. Moreover, if one of the beneficiaries should object, that causes another situation to happen, meaning you cannot take that action like selling the home of your loved one. It would then require court approval, and that's what will protect you and the estate. The only time I had someone who objected to the notice of proposed action was because they truly didn't understand what they were reading, and once it was all explained to them, they changed their mind. They checked the box that said that they approved of the notice and the action that the executor was about to take, and we moved on with the sale of the home. So let's talk about the procedure for selling a home in probate. Once a purchase agreement is negotiated, we then open escrow. My team will send a transaction cover sheet to all the parties involved in the transaction, and that includes your attorney and also your buyer's lender. Based on what we send, that transaction cover sheet and the purchase agreement and any counteroffers that went back and forth between you and your buyer, we send all that to your attorney so that they can get busy drafting the notice of proposed action to be sent to all the beneficiaries. We want to be sure that the notice is sent via notice to beneficiaries. Your attorney will include the proposed price and the sale date on that notice of proposed action. And some of the attorneys will actually include the purchase agreement and any counteroffers along with that notice to be sent off to all the beneficiaries. So the next step is they serve that notice to beneficiary on everyone that's listed in the petition, the probate petition. That would include the heirs or beneficiaries and anyone that is named in the will, and also anyone who requests special notification. A properly served notice of proposed action includes sending that notice via mail, and it expires after 15 days. I always contact the attorney and I ask for a copy of the notice of proposed action. They typically just email it to me, and that way I am fully aware of what day it went out, was mailed to the beneficiaries, and when it should be expiring. Because we do not want to close the transaction, finishing it up, before that 15-day period of time. So you can see that the notice cannot be served on the same day as the proposed action. For instance, if we planned on completing a transaction selling the house on May 15th, the notice would have had to gone out at the end of April in order for us to be able to hit that May 15th date. Occasionally, attorneys will have an agreement with the beneficiaries that they can serve the notice of proposed action via email. So then the attorney can email that notice to the beneficiaries. They will need to print it out, they will need to complete it properly and sign and date it, and then return it back to the attorney. That will help to shorten the timeline from the 15 days to as soon as the attorney receives all of the notices of proposed action fully executed by the beneficiaries, then the notice has been completed and we can move on with the proposed action, such as selling your loved one's home. It's really important that all of the beneficiaries complete the notice of proposed action in writing. The other option of the notice of proposed action is that if no one objects after that 15-day period, the notice expires and we can go forward with the selling of the property in probate. I'll bet you're wondering what happens if, for whatever reason, we need to sell the home faster than a 15-day period. This can occur when there is a cash offer and the timeline is shortened for whatever reason. I'll be honest with you, I typically do not do less than a 21-day period of time for any type of escrow, including when the property is being sold for cash. But if you're in a situation where you need to sell the house within a 15-day period, you have two options. First, you need to deliver the notice of proposed action in person. I did have a client that he printed out the notice of proposed action that was sent to him. He was the executor of the estate, and he drove it to his brother an hour away and had his brother sign it and date it, and then he got it back to the attorney within 48 hours. Just a little side note, on page 2 of the notice of proposed action is the space where you can either have approval or object to the notice and the action that's about to be taken. Once we receive the notice of proposed actions signed and dated by all the beneficiaries, then we can go forward with the next step towards selling the loved one's home. There are a few circumstances where you may want to consider court approval even if you have full authority under the IAEA. This is something that you'd want to talk with your attorney about, and these are the cases. And I believe that just because you can do something doesn't mean that you should. So let's talk about the circumstances that you might want to consider going forward with court approval. And again, although you have that approval under the IAEA, it's not always best to exercise that authority. Now, I'll just be honest with you, I haven't had a circumstance like this, but I did want to share it with you. For example, if there is hostility among the beneficiaries or between the beneficiaries and the personal representative, the executor or administrator, or if the proposed action involves a highly complex transaction, then you might want to consider going forward with court approval regardless that you have full authority. But again, that's something that you should speak with your attorney about. I hope you found this of value. If you did, please subscribe to the channel, hit like and the bell button so you're notified of my weekly videos all about probate real estate. And I'll see you next week. Thanks for watching.